Okay, Shannon, you can put us on. Okay, Hilltop Manor Inn versus auto owners. Counsel, could you please each state your appearances for the record?
Zach Bonham for Hilltop Manor Inn.
Mr. Casey, you're muted.
I'm sorry. Good morning, Your Honor. Brian Casey for Auto Owners Insurance.
And good morning, Your Honor. Christopher Jennings appearing on behalf of Warner Adjustment Company.
So your case appears probably in more places on my docket this morning than any previous case since I've been on the bench. So I'm not even going to try to guess who filed first or who wants to go first. So who filed the first motion?
Your Honor, Auto Owners did.
Well, then let's hear from auto owners first.
Actually, it was Warner that filed the first one. They filed the objection to the 7-day. That was what started the whole avalanche of motions.
Okay. Avalanche. I like that. So does it make the most sense to start there?
Well, honestly, Your Honor, without getting into the substance of their motions, the objection to the 7-day and the two motions to set aside the order are nearly exact, the same exact arguments. So I don't really care. It's the same argument.
Right.
And Your
So
Honor,
since Mr. Bonham doesn't seem to care who goes first, do either of you gentlemen have a preference?
I do not, Your Honor. If he wants to do it chronologically, he is correct that Warner's objection was the first filing.
all right.
Mr. Jennings, do you have any preference?
No preference. I think that auto owners and Warner Adjustment have similar interests in the outcomes of the motion today with regard to what we're seeking. So I don't think it matters one way or another.
All right, Mr. Bonham, you win.
Okay.
All right, then we'll start with the I guess the objection or the motion to set aside the order that was entered with regard to the protective order that plaintiff was seeking. The motion hearing was originally set to be heard on March 5th. I was actually in the waiting room the entire time, and this court heard the motion between plaintiff and auto owners only. I know this was the case because my office ended up getting a call on another matter asking where we were, and we were waiting in the waiting room the entire time. So at the outset, the order states that all parties were present and had an opportunity to be heard. That's incorrect. I think maybe more importantly, the order is just simply too broad. The order specifically states that the discovery should be limited to Hilltop only in terms of interrogatories and requests for production of documents, and any discovery to non-parties is prohibited. Defendant Warner attached a transcript from the hearing, and the court specifically goes through this analysis and says that the written discovery requests submitted to Hilltop need to be directed in requesting documentation only from Hilltop. To the extent that Warner Adjustment or auto owners wants to send discovery to a non-party, it has to do that in accordance with the court rules. In other words, it needs to send a subpoena to that non-party for production of documents. Counsel for auto owners during the hearing acknowledged that that may have been proper and didn't object to that. So essentially what the order should have said is that the discovery, the written discovery that was to be answered were only those questions directed towards Hilltop Manor and not those questions directed to other non-parties. The transcript is pretty clear on that. I can put it up if this court would like to see it. We sent it to plaintiff's counsel.
There's no need. I remember it well. You have methods for discovering from a party. You have different methods for discovering from a non-party. Whatever the rules say, my order should reflect what the rules say.
And I think that's, and we had sent a proposed order that we had felt accurately tracked with the ruling of this court, where the order that was submitted by the plaintiff didn't track accurately with what the court had ordered. It is potentially too broad. And I think the manner in which plaintiff's counsel submitted it demonstrates just that fact. It was submitted under the 7-day order, but counsel for plaintiff sent it by snail mail. So counsel for defendant didn't even receive the order until March 17th, after the order had been entered with the court. Plaintiff's counsel didn't send a courtesy copy of the proposed order by email. He didn't seek concurrence or anything of that sort prior to submitting it to the court. And that's why defendant submitted not only an objection to the order under the 7-day rule, but also the motion to set aside the order or relief from a judgment in the event that the court felt that we were not within the 7-day requirement to object to the order. Our office.
All right, so before we go any farther, let me make something very clear. I can't order you to do your filings and exchanges solely by email. But I can order you, and I am ordering you. Every time you file something with the court, every time you serve a discovery request on another party or a response, you absolutely shall send a courtesy copy via email. And my order, whatever orders end up getting entered as a result of today's hearing, that had better be in one of them. That's what I expect to see. Everybody knows the mail isn't working. Email still works most of the time. I expect you to use it. So let me look at this proposed order. Mr. Jennings. All right, and Mr. Bonham, Mr. Casey, do you have any issues with the proposed order that Mr. Jennings has submitted? It certainly appears to reflect my intention from the last hearing.
My issue is
Okay, so let's at least get this addressed before we move on to whatever else is in front of me today. Go ahead, Mr. Bond.
My issue with it is that it doesn't say anything different than what our order already says, and it reflects what the court ordered. It says, for the reasons stated on the record, the motion was granted. And it also says that the discovery issued by auto owners and directed to third parties was prohibited, which is what this court ordered. So you can't send discovery through Hilltop Manor Inn for third parties. That's what it reads. We're really here for a form over substance issue. There is nothing ambiguous about this. Another issue is that if Warner had such a concern about this motion hearing, that's why they didn't file a response to it. They probably didn't file a response to it because they weren't a party to this. They were a part of the discovery issue that we had a problem with. That's why I didn't bring them into it saying, hey, Warner, your discovery issues are a problem. Because they weren't. They didn't serve them. It was an issue with auto owners. So for Warner to step in now and say that they have a problem with what this order says, they lack standing. They weren't part of the motion. They didn't file a response. They didn't show up for the hearing, and they didn't object in time. And they're not part of the order that this court entered. So I don't see why we are here for something that doesn't affect them. And if you look at the emails, I have several emails with Mr. Jared that says this does not affect your client. It only stops auto owners from sending discovery through my client to third parties. Why are we here?
Well, Your Honor, I have to
hold on. I want to find the order that I actually entered. What was the date of the order?
March 6th.
Yeah, the order was entered on the 16th of March.
All right, let me see if I can put my finger on it. At this rate, this file is going to expand exponentially. So let me, which makes it hard for me to find things. Did somebody attach it as an exhibit? Because there's so much here. And just for your benefit, when orders get filed here in the official court file, instead of the nice, tidy chronological pleadings clip that all litigators are used to dealing with, I deal with a hodgepodge that is clipped in the file in the order that the clerk clips it in the file. They don't appear chronologically purely. I mean, somewhat, but not. And it's just hard to find stuff. Did any of you attach it as an exhibit?
Your Honor, if I might, yes, we attached it as Exhibit E to our motion, but
Thank you.
It's very simple. And if you'd like,
That's why I want to. No, I want to see it.
It's also
So I'm looking. Go ahead, Mr. Bonham.
No, you're gonna say it's Exhibit 2 to our response to this particular motion in front of the court from Warner. It may be easier to find.
Okay, all right. I found that. Thank you. Hold on a second. Let me read it. All right, thank you. Mr. Casey, you wanted to address the order as well.
Yes, Your Honor. I obviously disagree with Mr. Bonham's interpretation of the order he submitted, because as I read it, it says that all discovery requests by auto owners to non-parties are prohibited. And that's certainly not the court's ruling, certainly not the court's intention. Mr. Jennings' proposed order, which we agreed to, sets it out so that there is no ambiguity. We certainly have the right to issue subpoenas and do discovery as to non-parties following the court rules. The only issue at the March 5th hearing was whether or not we could obtain the discovery we sought through Hilltop Manor, which was also directed to Hilltop Contracting and to Mr. Kowaleski. We agreed with the court back then that that was improper. You ruled that it would have to be done separately, and that's all we're asking, is that the order be clarified to reflect that does not apply to all non-parties. We certainly have the right to do discovery as to non-parties.
Connor,
All right, so
the response from auto
go ahead, Mr. Bonham.
The response from auto owners, or their motion in paragraphs 10 and 12 says they received the 7-day order, the proposed 7-day order. They reviewed it and chose not to object to it. Why are we having this issue now? They had it. They didn't object. They had an opportunity. There's no point to modify the order or take back the order and put a new one in. We know what it says. It says what it says. It says for the reason stated on the record. And it says auto owners can't serve the discovery to my client to third parties. Why are we here?
Your Honor,
I have signed the order submitted by Mr. Jennings' office. Let's move on to the other issues.
thank you. Your Honor, auto owners also has a motion to compel discovery. Again, by way of background, written discovery requests were served on the plaintiff on February 3rd, they didn't respond to them in a timely fashion, but they did file the motion that was heard on the 5th. And at that time, as you just heard, you decided that some of those requests, which were requesting information from related entities to Hilltop Manor, but are separate legal entities, had to be done separately. All the other discovery requests, though, have not been answered. And we've had nothing but problems getting information from Mr. Kowaleski. And we need an order, and we're asking for 14 days that they give us complete information to respond to the interrogatories and requests to produce, which were served on February 3 and are now over 2 months overdue.
All right, let me hear a response to that.
Your Honor, I love the hypocrisy from auto owners. On one hand, they're filing a motion to set aside our order. On the other hand, they're filing a motion to compel to enforce the order. So which one is it? So on the issue that we don't have a resolution to the motion for a protective order until today, it was procedurally inappropriate to file a motion to compel. That's one issue. The second issue is MCR 2.309C requires that the moving party confer in good faith prior to filing the motion to compel. That never happened in this case. I never was contacted by Mr. Casey or Ms. Griffin about this, which is required. So procedurally, it should be denied. But had they reached out to me and just picked up the phone or emailed me, I would have told them, hey, when we get this resolved, there's no problem. I have no problem of providing these documents. The court ordered it anyhow. But I also would have told them that Mr. Kowaleski's 22-year-old stepson was tragically killed in a head-on car crash on March 25th, which I attached as an exhibit. As anybody can imagine, the family is absolutely devastated and they're in mourning. So I don't have an opportunity to meet with my client. He's emotionally not in a state right now where I can talk with him about a lawsuit. I'm not saying that I'm never going to provide these documents, but I'm asking for a little empathy from the court. If they're going to order this, I mean, we're going to provide the responses, but I need at least 21, 28 days before I can get these documents together, because what they're asking for is still a high volume of documents. And my client emotionally is not there right now because, like I said, they just buried his son 2 weeks ago, less than that. So I need some empathy from the court to understand that.
I'll grant the request for 28 days.
Thank you.
If you run into problems with the family, and who knows, I can only imagine how upsetting this would be, and how difficult it is to pick up the pieces and move on. If you need more time, just because your client's just having difficulty focusing, I will be sympathetic to that request.
I appreciate it.
But I would appreciate that there be better communication among all counsel as we move forward. I think all of this could have been avoided today. I agree with Mr. Bonham on that issue. Let's try to follow the rules, specifically that you confer in good faith.
Thank you.
You got to pick up the phone. You got to have a conversation. You got to do an email. You got to do something. Don't file a motion that says you conferred in good faith when you didn't. I don't want to see that again. If I see it again and it didn't happen, and I don't care who does it, there could very well be an award of sanctions. I'm not awarding any sanctions today. So what else we got?
I think that's it, Your Honor.
Your Honor, Defendant Warner also has a motion to compel more specific responses from the plaintiff.
And I saw that, and I saw the response that apparently Mr. Bonham answered your discovery requests as written, apparently not as you intended them.
So first, Your Honor, we did confer with opposing counsel in good faith to try to resolve this issue. And Mr. Bonham didn't mention one thing about the death of his client's family member. So for him to bring it up today is kind of a red herring. But I don't want to get bogged down on that. Obviously, if any attorney would have reached out and said, I
Your Honor,
needed
I want to object real fast. The fact that he would mention
additional
that it's a
time.
red herring, that I would bring up my client's stepson's death.
I didn't
I
interrupt.
don't know. I don't know what kind of sanction would even be appropriate for something like that. So I asked that Mr. Jennings watch his mouth when he said something like that about someone's child.
It's clearly the death of a client's son is not a red herring. Go on, Mr. Ed Jennings.
So when we conferred with Mr. Bonham trying to get this issue resolved, we spent very specific requests asking for him to identify specific documents that went to the heart of the interrogatories and request for production of documents. All he said in response was, see the documents submitted with initial disclosures. It's not our job to go out and find the documents that Mr. Bonham and his client are relying upon to prosecute this case. If they can't produce those documents and identify them specifically, then this case shouldn't be going on at all. It says specifically, please attach any and all documents which support it and identify that specific portion of the document that supports it. So plaintiff didn't supply any documents, nor did plaintiff identify the specific documents. And that's why we filed the motion to compel more specific responses. So for plaintiff to sit here and say that they were too sloppy and they didn't understand what happened, it was a Scrivener's error. So for us to have requests for admission throughout the whole one, instead of it identifying requests for admission number 2, 3, 4, that happens all the time. And yes, it was an oversight on our part, but it didn't prevent him from understanding what the requests were seeking. It's the spirit of discovery here, Your Honor. Plaintiff isn't cooperating at all.
Mr. Jennings, fix your Scrivener's error, reserve your requests. Mr. Bonham, I expect them to be answered exactly in the manner required under the court rules.
Your Honor, if I just may briefly, to fix that issue, Warner already submitted about a week ago interrogatories, and then I think earlier this week, another set of interrogatories and production requests. Because what you usually see after request for admission is a interrogatory asking for a full explanation of why the denial is being put on the record. They didn't do that. They put a production request. We put the records out there and we identified the verbal statements, which isn't even a record, which is really the heart of the issue. So we're going to respond to the second and third set of discovery that they've provided. If they want to reserve their discovery, that's fine, but their Scrivener's error is their problem, because if I respond to something that's not on the paper, then I am not responding to the discovery that they served. So I'm not supposed to guess or infer of what they put, but I will respond to whatever they served to us, Your Honor, in good faith.
All right, that's what I expect to see. Anything else today, gentlemen?
No, Your Honor.
No, Your Honor.
Thank you. Thank you. I don't want to have another hearing like this again, gentlemen. You better work hard to resolve this. We have another hearing like this. There's likely to be consequences for someone. Let's move forward and address the merits of these claims and stop this kind of episode from happening again. Have a good day, gentlemen.
Thank you, Your Honor.
You too, Your Honor. Have a great weekend.
Thank you. All right, this thing is absolutely full of stuff that is judges' copies and stuff that isn't. So here,
Okay, I'll sort
you
through
get
there.
to sort it all out, and that order needs to be entered downstairs.
Okay.
Good night. Okay, I think I've only got some pre-trials.
The JNAT at 9:30.
Pre-trial. Shannon, this doesn't need to be on